Good afternoon. I'm Andrew King Reese from the University of Montana School of Law, and we appreciate you all joining us for our webinar today on the rule of law. Preservation is insufficient, thinking about reform and a more equitable rule of law. We have a couple of business matters. First, thanks to the ALS and the Mellon Foundation for sponsoring this webinar. It's part of a 5-webinar series. So we're very appreciative of that. Clearly, there's been lots of discussion recently about the rule of law and how democracy are under attack. It's fitting that we are here today in having this discussion on a day when the government has been shut down. Nearly every day, we see calls for preservation of the rule of law and prevention of the demise of our democracy, a slide toward an autocracy. Preserving the rule of law is essential. Debatable, we'll talk about that today, but certainly insufficient due to the massive inequality in our society and the racial, economic, and social hierarchies that have been created and perpetuated by the American democracy and the rule of law. So in addition to joining a chorus of people calling for resistance to an advancing autocracy, we want to make sure that there is space for a conversation about the need to reform or improve the rule of law and American democracy. As a housekeeping matter, there is no chat function today, so please put any questions you have in the Q&A. We'll be monitoring that throughout, and we will get to those, as many of those as we can. So let me take a minute to introduce our panelists. We are very fortunate today to have an extraordinary panel of democracy and rule of law scholars, thinkers, and reformers. So I'm going to go in alphabetical order, starting with Zamir Bendan from Temple University School of Law. Practice areas: criminal defense, legal aid, holistic legal services to nonprofits. Teaches and writes in the area of constitutional law, criminal law, racism, and American history, focusing on ways the Constitution perpetuates racism. Paul Gowder from Northwestern School of Law, practiced as a civil rights and legal aid attorney, teaches constitutional law, torts, critical race theory, and professional responsibility. He's written 2 books on the rule of law: The Rule of Law in the Real World, The Rule of Law in the United States, an Unfinished Project of Black Liberation. Amy Kopczynski from Yale School of Law. Amy teaches constitutional law, intellectual property, law and political economy, is the director of the Law and Political Economy Project, writes in the areas of IP law, health, international law, constitutional law, focuses on how law shapes and is shaped by political economy. And Jocelyn Simonson from Brooklyn Law School. Jocelyn practiced as a public defender with the Bronx Defenders, writes and teaches about criminal law, criminal procedure, evidence, and social change, particularly through bottom-up democratic engagement with institutions of local control. Recently published Radical Acts of Justice: How Ordinary People Are Dismantling Incarceration. So welcome, panelists. I'm very excited that you're here today and really excited about our conversation. Our format is going to be that our panelists are going to have a few moments to make individual remarks, and then we will have time for discussion and Q&A. So we will start with Zamir.
Thanks, Andrew, for that. So, on March 4th, 1861, Abraham Lincoln would be inaugurated as the 16th president of the United States. And at the time of his inauguration, he was facing what I think many of us can agree, the greatest crisis in America's constitutional history. At the point that he was inaugurated, there were 7 states that had seceded from the Union and were in the process of writing their own constitution and starting their own government. And so in his inaugural address, Abraham Lincoln attempted to speak to these very issues and to speak to the idea that the rule of law was being abrogated by those who were withdrawing from the Union, and to encourage them to promote the rule of law. And so Abraham Lincoln's inaugural address is a very fascinating document because he calls out those who were seceding from the Union. He has a theory that the Union was older than the Constitution itself, and that individuals could not break apart from the Union without having conversation with the other states and it being a unanimous agreement among the states. And he venerated the rule of law, and he venerated the Constitution of the United States. And here are some of the things that Abraham Lincoln said. He said, "I have no purpose, directly or indirectly, to interfere with the institution of slavery in the states where it exists. I believe I have no lawful right to do so, and I have no inclination to do so." He later on made references to states' rights, which he said was essential to that balance of power on which the perfection and endurance of our political fabric depend. And then he also made reference to the Fugitive Slave Clause, which he said was the, quote, "most conclusive evidence that chattel slavery was protected by the Constitution and is in no way, quote, endangered by the now incoming presidential administration." And so what Abraham Lincoln described was a pro-slavery rule of law. And he talked about how the Constitution was intended and understood to protect chattel slavery. He talked about the Supreme Court upholding the peculiar institution. He talked about Congress enacting pro-slavery legislation. And then he talked about the importance of what? Debating amongst each other so that we can reach consensus on issues. He talked about the amendments process. If you don't like certain things in the Constitution, then get people together and get the states together and go ahead and amend the Constitution. And now the reality is, if African Americans had to choose, which they did have to choose ultimately, between supporting Abraham Lincoln and supporting the Confederacy, clearly they supported Abraham Lincoln, because even though Abraham Lincoln was talking about the Constitution promoting slavery, what the Confederacy was pushing for was a whole lot worse. And so those responsible for the crisis back in the day were certainly the worst of the two parties and worst of the two dominant ideas that existed back in the day. But the mistake that some made then was thinking that the issue was just related to the Confederacy, and not thinking of the idea that Abraham Lincoln's vision of democracy was also a problematic vision of democracy, and his call for the adherence to the rule of law was a problematic call as well, because both promoted racism, both promoted chattel slavery. One was simply worse than the other. Now, as history would have it, neither vision of democracy prevailed. The Confederacy vision did not prevail, and Abraham Lincoln's vision did not prevail. Ultimately, chattel slavery was abolished through bloodshed, unfortunately, and then ultimately by constitutional amendment. But I bring this idea to speak to what I think is a disturbing trend within and without legal academia, which is that the rule of law is this inherently unqualified good. It's not. It can be good depending on the substance of the law, depending on the values of the nation, but adhering or calling for the rule of law without talking about anything else is not an unqualified good at all. And I want to bring that up to present times because, of course, fast forward to 2025, we're dealing with another constitutional crisis, one that is not as bad, I would argue, as obviously the union splitting. It hasn't gotten there yet. Who the hell knows? But there's a president who has decided that he's going to defy judges, who's going to do his own thing, exceed his power, and things like that. And unfortunately, from the American legal community, the public denunciations have almost been uniformly the same. Donald Trump is exceeding his authority. We need to protect the rule of law. And there is no critique whatsoever of racism, classism, sexism. There's no critique of the values that have been promoted in American history. And decades-old rule of law and colorblindness critiques have been unheeded and completely unacknowledged. And so if we're going to talk about the rule of law as a good, we have to recognize that it is a qualified good. And it can only be good if it goes in accordance with good values and if it goes in accordance with a substance of the law that is respectable. And even those who may try to argue the point, at the end of the day, tacitly recognize that this is the case. A lot of times when people talk about the virtues of the rule of law, they bring up things like Brown versus Board of Education and the Reconstruction Amendments and enforcement legislation and things like that. They're brought up for a reason. Nobody argues for the rule of law today and brings up Plessy versus Ferguson. Nobody argues for the rule of law, brings up the Fugitive Slave Act of 1850. We bring up the stuff that emphasizes the good values, to bring up the stuff that emphasizes egalitarianism. And so the rule of law has to accompany egalitarianism. And when we critique President Donald Trump or whoever comes after him for disregarding the rule of law, those critiques have to come with an indictment of white supremacy, an indictment of American racism, classism, sexism, and the like, because it is only with that indictment then the rule of law can actually be a good for society. And so I'll go ahead and pause there.
Excellent. Thank you, Zamir. Paul?
And this is a fantastic transition because my role really on this panel is, I say I come not to bury the rule of law, but to praise it. But in doing so, I think taking up Zamir's challenge, I have to say that Abraham Lincoln was wrong in his inaugural address. And so the way that I want to start with that, so I want to actually quote Charles Langston. So, Langston, as I hope many of us know, was a important Black abolitionist. And this, what I'm about to quote to you, was from the speech that he gave before the court as he was being convicted for his participation in the Oberlin Wellington rescue, where he and other Underground Railroad activists forcibly freed some people from kidnappers who were dragging them south to slavery. And so here's what Langston says. He says, "If ever again a man is seized near me and is about to be carried southward as a slave, before any legal investigation has been had, I shall hold it to be my duty, as I held it that day, to secure for him, if possible, a legal inquiry into the character of the claim by which he is held." And I go further. I say that if it is adjudged illegal to procure even such an investigation, then we are thrown back upon those last defenses of our rights, which cannot be taken from us, and which God gave us that we need not be slaves. And so here's what I think Langston is saying here. I think Langston is saying that the Fugitive Slave Act is actually a counterexample to the claim that the United States had anything like the rule of law, that, we can talk about the Fugitive Slave Act and the rule of law, but we have to understand the rule of law as a basis for critique of the Fugitive Slave Act. And he tells us why. Because in this excerpt that I gave you, he set up a dichotomy that actually would have been familiar to the founding generation who'd understood, or at least some of whom had read their Thomas Hobbes, a dichotomy between a state of civil order and a state of war. Langston is saying the Fugitive Slave Act puts every Black person in America outside of the legal relation with the US. Why? Well, because it subjected every Black person in America to arbitrary power, to being kidnapped into enslavement without a fair trial. And so by putting every Black person in America out of the civil condition, it started a state of war. And being in a state of war, he had the right to do what he did, namely use force to resist that lawless law. And so I think that President Lincoln was simply wrong to understand the Fugitive Slave Act as consistent with the rule of law. And I would go further and suggest that the antebellum Americans were wrong to understand slavery itself as consistent with the rule of law. And this is something that's surprisingly controversial, even among present day scholars. I think a lot of folks influenced by some of Mark Tushnet's early historical work on, in the American law of slavery purport to think that you could describe a slave rule of law. But I actually claim that you can't. And, the quintessential, one more quote, right? The quintessential statement, obviously the sort of extreme statement of the law of slavery that I think quite clearly rules it out as something that could be consistent with the rule of law is, of course, that quote from State versus Mann that many of us are familiar with. I'll quote again. Such obedience is the consequence only of uncontrolled authority over the body. There is nothing else which can operate to produce the effect. The power of the master must be absolute to render the submission of the slave perfect. We cannot allow, there's a bit I'm skipping here, we cannot allow the right of the master to be brought into discussion in the courts of justice. The slave, to remain a slave, must be made sensible that there is no appeal from his master, that his power is in no instant usurped, but is conferred by the laws of man at least, if not by the laws of God. And so that statement again, like explicitly says that the slave is in effect in a state of war with the United States, that the slave was a person who lacked the protections of law, who was subjected by acts of law to pure arbitrary power on behalf of those who are called masters. And so again, I think that we can see a rule of law critique of that. And that rule of law critique extends into the present and extends into the critique of the replication of the Fugitive Slave Act, or at least of many of the institutions of the Fugitive Slave Act in, for example, Donald Trump's abuse of the Alien Enemies Act, to once again carry people away into, in this case, torture prisons without trial, without hearing. And to my mind, the skepticism that progressives have had for the rule of law is understandable, but it's understandable because so much of American constitutional history has articulated a corrupted conception of the rule of law, has articulated, in fact, the slaveholders' conception of the rule of law, which claimed that property rights are the primary value that the rule of law is meant to protect, and hence that the rule of law commanded rather than opposed the Fugitive Slave Act as a form of protection of property rights. And so I think that the obligation of progressives is to resist the property rights conception of the rule of law and defend the human rights conception of it. Thank you.
Excellent. Thank you, Paul. Amy, I think you're next.
Great. So I think a lot of what I'm going to say is going to kind of resonate with what we've heard already. I mean, I think one problem with the kind of rule of law discourse, right, the kind of conventional rule of law discourse around us, is that it does tend to be depoliticizing with respect to the actual qualities of the law we're talking about, right? It's a sort of like, at least we can all agree on the rule of law, right? And as if we can just sort of set politics aside and agree on the rule of law. But of course, the law that we have, and this is in a way Paul's point and Zamir's point, the law that we have is actually quite relevant to whether or not you think there is something that is worthy of the rule of law, and also whether or not we're substantively achieving the ideals that the rule of law might call into mind, right? And so there's plenty of law that we might, that I would want to deeply critique, right? And suggest that we ought to, both historically and today, transform. And so there's something kind of unsatisfying about a rule of law discourse that is often as if we're getting back to the rule of law, as if we're maintaining the rule of law, as opposed to Paul's sort of, what if we could get to the rule of law, right, way of thinking about it. Actually, Paul, your comments made me think of Astor Taylor's book, Democracy May Not Exist, but we'll miss it when it's gone. And it makes me think this is a, like, the rule of law may not exist, but we'll miss it when it's gone kind of moment. She's trying to say about democracy sort of similar things, like it's an aspiration to which it never exists, but we keep trying to get it. Which is to say, I think there's an important critique of a certain kind of depoliticizing rule of law discourse, right, which tends to defer questions about the justice of law and tell people who think that law should be transformed that they're doing too much, and the most we can do is kind of stick with often the procedural rules that we have. This is kind of the Abraham Lincoln moment, right? Stick with the procedural rules that we have so that things don't get out of hand. I think that's a kind of a problem that we might think of as like the rule of which law problem. Like there could be a lot of different laws, and so we ought to be able to challenge the law that we have, and the rule of law discourse sometimes prevents us from doing that. But then there's a second kind of thought I wanted to sort of introduce as the like, which rule of law are we talking about? Kind of like which rule of law? There could be a lot of different versions of the rule of law. And here, I think we could conclude, and this is in a way, I think what Paul is inviting us to do, that there are virtuous kinds of legal orders that we want, for which there's going to need to be law, right? If you, as I do, care deeply about access to healthcare, it's hard for me to imagine a world that would provide access to healthcare in an equitable way without law, right? So then I'm going to care a lot about there, in fact, being something that we could call law that we actually can figure out how to apply to help achieve these collective ends and virtuous ends that we have, right? And that law might also need to have process elements to it, right? Like it might be important that you could go and say, well, wait a second, I'm not getting the treatment that I deserve. And so there's got to be a process for figuring out whether that's true, right? And so out of a set of constitutive values about democracy, the equality of persons, the kinds of substantive world we want to live in, one can articulate a kind of rule of law that has both substantive elements and procedural elements that I think are quite important to our vision of the good life, right? And that might be very different than the rule of law that would be talked about in a moment of like, let's just defend the rule of law, right? I could sit here and tell you that I think judicial review has difficulties, real difficulties from a democratic perspective, or that I think the Senate as an institution is pretty anti-democratic. So there's deep parts of our procedural infrastructure that I think should be different than they are. And therefore, in that way, it provides a challenge to a certain kind of rule of law, which is to say the rule of law that we have is not a good one, and we ought to have a different one. I also think if you're thinking pragmatically, as many people are in the present moment, about sort of how does one contest what is obviously, you might say an anti-constitutional administration, a lawless administration, right? Talking about the sort of maybe I'll say deracinated rule of law in this way, I think is often less effective than talking about the substantive values that should lead us to want to, let's say, have constraints over police officers or people with guns wandering through the streets with masks on, right? That there's something substantive that we ought to be challenging in the vision of, or that there's something substantively wrong with a vision of the world where the military shoots boats out of the ocean because they seem to, no one can ask, do you know who's in those boats? Do you know what's happening? Like, you could just say, well, that's just process, like figuring out what the boat is or figuring out who the person is who you're arresting. But it's not just process. That's deeply integral, right? That the government should have to account for who are they arresting, who are they shooting, right? And so like this idea too, that I think we chafe sometimes at the idea that there's like a process rule of law. I think there has to be, our substantive, I guess I would say, like, it's a kind of complicated, convoluted way of saying, I think we have substantive visions of the good that imply actually that certain kinds of ways of doing things, like we pass a law and the executive should have to actually pass a different, like we should have to pass a different one before we change course, that those could be important to our substantive values, and that we actually see, you could even go so far, I think, as to say this is an administration that itself is offering us a picture of a rule of law. It is not a good rule of law. It is a rule of law where the executive doesn't have to follow any constraints, including whatever Congress tells them to do, including rules of engagement, including rights of individuals who are being, picked up on the streets, but you still have to pay your rent, right? Like, you just try to go into housing court and say, but apparently there's no rule of law anymore. Right? Like, no, that's not going to work, right? So there is a version that we're being offered here, which is very juiced up on executive power. It's personalized rule. That is a deeply problematic way of understanding a certain kind of rule of law. I think we should be talking about a different kind of order that we want. We should talk about it substantively and then work out from there. How do we talk about the processes of why would we want to defend, let's say, Congress's right over the executive, or why would we want to defend process before you shoot somebody? And so that we can actually engage people at the level of values, which I think is actually ultimately more effective than simply trying to do this thing where we say, but the rule of law.
Excellent. Thank you, Amy. Jocelyn?
Great. Thank you. What a pleasure to be here and to follow all three of you. I'm gonna, I think, just sort of pick up the thread that Amy left with and talk about kind of substantive values underlying rules and laws and where that takes us when we talk about the rule of law. Those of us on the panel did have a meeting where we met, I think it was at least a week ago, and we were talking about what we were going to talk about. And I was like, well, it depends what happens in the next week since things are happening so fast. Sure enough, in terms of the rule of law in the news, these last few days, it was the indictment of Comey that has people saying that the rule of law, I think Hakeem Jeffries has declared, okay, now the rule of law is over because of the indictment of James Comey. There's lots of headlines sort of connecting this indictment to the rule of law. And I think there's sort of general agreement that the rule of law has not been followed in this indictment in different ways. So I thought I would sort of tease that out a little to see what it is that, the at least liberal establishment thinks is wrong about it and what we can do with that, in part because I do think a lot about criminalization what it means to think about substantive values in relation to criminalization. So I understand the connection between the Comey indictment and the rule of law to be meant in a couple of ways. One being that he's been deliberately targeted as a political enemy, and that's the purpose of the prosecution. And another being that he's being charged with flimsy evidence that some prosecutors refuse to proceed with, but this prosecutor has decided to proceed with anyway. And that those together point to a lack of neutrality in the law or the criminal law or some kind of weaponization of criminalization. And it is a weaponization of criminalization. But it's not a new one. Both are things, this idea of being targeted for identity and then the use of flimsy evidence are both things that people who are policed and criminalized have long been saying they experience. When I was a public defender in the Bronx, many of my clients would recognize these two ideas, prosecution at the whim of law enforcement and prosecution because of identity as part of what led to their criminalization. It operated in different ways, of course, but or to go back in time even more, I grew up on the Upper West Side of Manhattan, jumping onto the back of the crosstown bus without paying regularly. And needless to say, as a white girl in a well-off neighborhood, I did not end up with a criminal record. Meanwhile, boys my age who are Black or Latino and live farther uptown were regularly arrested for jumping a turnstile, the same action, but a crime for one identity, one place, and one law enforcement strategy, and not a crime for me. But that was seen as the rule of law at the time, and even now you could argue fits certain dimensions of the rule of law. And so it's sort of to figure out what is it that makes us call out the Comey prosecution as being a violation of the rule of law and not everyday practices of criminalization is something I'm interested in, but also I think this is a chance to notice that and to say if we really care about the rule of law, then we should be looking at these larger practices. In recent months, I've been returning to the writings of political prisoners from the 1970s who were writing about their experiences and connecting it to the rise of fascism. And I know I'm not the only one returning to them. I've had conversations with quite a few people and heard references to it. But I've been returning in particular to the writings of Angela Davis and George Jackson, who were incarcerated and targeted as members of the Black Panther Party. And when Angela Davis wrote from jail in 1971 about what she called incipient fascism, the beginnings of fascism around her, she said that what she was experiencing was fascist. She was being targeted for her political beliefs, much like James Comey is today, but that although it might seem limited to the Black Panther Party or to people who, she talked about Governor Reagan labeling this form of activism as violent and dangerous, she actually connected it to larger law enforcement practices and a sign that fascism would be expanding if we did not make certain connections. She warned that fascism was coming for everyone, and her evidence was not just herself, but the other people in prison who were labeled as criminals for actions that came from a cycle of poverty, policing, and prisons if we didn't notice how the state can twist criminality and point it at those it disfavors. And so now if we take a step back, on the one hand, it's scary to think that we could all soon be experiencing what marginalized people have been experiencing throughout our history. But I think fascism has come for all of us in a lot of ways. And so then on the other hand, it's an opportunity to forge solidarities in a way where we aspire to the rule of law, sure, but to a rule of law where people aren't subject to domination because of their marginalization, their identity, their class, their nationality. And that rule of law looks very different if we think about it materially and we ask what legal and political conditions are necessary to foster solidaristic ways of living together. So instead of asking to return to a world, right before this Trump administration, where good immigrants can stay in the United States, but bad ones who've committed scary crimes, should go. We could recognize instead what looking at, say, Comey's prosecution tells us, which is that criminality is constructed by our law enforcement practices and by our politics and by underlying dominant ideologies. It's not a neutral thing. And so we could seek out policies that move beyond good and bad people to think about providing resources for everyone to be better, for everyone to do, be the best people that we can. And so then the danger of saying that James Comey is the moment where we lost the rule of law is that we lose sight of the long history that the other panelists have been talking about the unequal distribution of legal benefits, about white supremacist histories underlying what we're surrounded by. And then we forget also to reach for like a more emancipatory future for the substantive laws and visions that Amy was alluding to. The state is going to do somersaults to label someone who threatens it as violent or criminal. And in some ways, our current moment helps clarify this more than ever. Suddenly everyone with a left political viewpoint is a domestic terrorist and supporting political violence. That doesn't feel right. That doesn't feel real, but it shouldn't mean that all the other criminal laws are real. It should help us see that they're politically constructed. And so if we call out this construction of criminality happening in real time, or this construction of other forms of legality, I'm focusing on criminality because it's what I think about. If we call it out, it's a mistake to say this is wrong and we had it right until now. Just as it's a mistake to say the problem here is just with a lack of a rule of law without, as Amy suggests, asking which rules, which laws, and which substantive values underlie them. So I can stop there because I want to circle back and hear everyone else some more.
Excellent. Thank you. So amazing, really thoughtful ideas. Just to open it up now for any reactions to any of the things that were said. What I heard repeatedly was sort of a question about what are the substantive values. So should we continue a conversation about the rule of law, or should we really put our energy somewhere else, substantive, legal, material aspects of the world we're envisioning? So I open that up. Paul, you want to jump in there? Great.
Yeah, sorry, I had second trouble unmuting. But I in a way, I feel like one question that what I heard from Amy and Jocelyn really prompts me to ask is sort of how much ambition do we want to bundle into the concept of the rule of law, right? So when I said Amy, when I heard Amy say that, Trump is giving us a certain kind of vision of the rule of law, the vision that she described that I agree Trump is giving us is what, rule of law scholars would often call a dual state. From Ernest Frankel's description of Nazi Germany as really this sort of combined idea of a legal state for ordinary economic affairs, but then a prerogative state for matters essentially of executive will. And so for me, as somebody who wants to put a lot of work in the rule of law. I want to make use of that description to say what Donald Trump is giving us actually is not a vision of a rule of law. It's of something alien to the rule of law, because the dual state, this kind of Schmittian state of exception that the president can always step into, is kind of the antithesis of the basic idea that power has to be controlled. And I think similarly with Jocelyn's, I think, apt remarks about the criminal justice system, for me, it seems less a failure of the rule of law and more a failure of rule of law discourse, that people haven't been pointing out that broken windows, again, is just like wildly contrary to what I see as a kind of basic rule of law principle, that choices about whether or not the state inflicts the violence of the criminal justice system on people ought to depend primarily on the correspondence between their conduct and the law, as opposed to, their race, where they happen to be found, or whether they've pissed off the president. I mean, a couple years ago, I published this like way too long paper called "Is Criminal Law Unlawful?" trying to sort of highlight that all of the rule of law critiques that the sort of Gorsuch crowd were making of the administrative state also apply to the practices of policing. But like, those critiques are available to us from within rule of law language. And so I think our task is to really ask, like, do we want to use rule of law language to raise those critiques, or do we think some other language would be more useful?
Excellent. We'll go Amy and then Zamir.
Great. So I'm a little newer than you are, Paul, to the rule of law stuff, but I've been reading some of the dual state, literature that you referenced there. And I think one thing that I wonder, and this is going to connect to the points you were making, is whether it's accurate to say at some point a dual state emerged, right? Or whether or not there are features of the state in a world, we could say the political economy that we have, right? Which in fact often has this feature of the economic order has to continue and there has to be a rule of law here. But over here we have prerogative, and that gets exercised only in particular ways, right? Against particular kinds of people. And the aperture is smaller or larger depending on where you are in a historical moment. That's what people like Angela Davis, I think, were talking about, was coming not to a view that the dual state is a momentary aberration where there's a Nazi moment and suddenly we get a dual state, but that in fact, and I think if we were to go looking for the places in our law that are particularly being exploited by this administration in its kind of dual state capacity, we would find the kinds of laws that the kind of racial order, the kind of legal order, the kind of political economic order that Jocelyn and Zamir are also talking about, right? Which is to say, actually, the rule of law that we've always had has features of this prerogative. And it's about how far it goes and who's exposed to it. And it becomes a certain kind of crisis when more people are exposed to it. People with more privilege are exposed to it. So I guess my challenge back to the rule of law folks is, what do you do with that basic descriptive account? And what does that imply for us about how much work the quote rule of law itself can do for us? Even though I'm sympathetic to the desire to take this administration and say like, oh, wow, they're totally out of bounds, it seems to me that there's a bit of that problem that people have been pointing us to for some time, that there's a kind of idealization at the heart of a conception of the rule of law that would keep it apart from sort of a conversation of like the fall into the dual state.
Thank you. Zamir.
In terms of reactions, I would say that Jocelyn's comments, I think, resonated with me a lot because it kind of speaks to what I was trying to get to with the historical example, which is how problematic I have found the rule of law discourse. In using the historical example, again, the argument can be made, well, for some individuals, the problem is, well, we're losing our democracy because certain states are seceding from the Union. But for other individuals, the problem is that they're enslaved. And that's been an issue long before there was talks of secession and things like that. And I think that issue has been replicated today, where a lot of people who talk about the loss of rule of law, there are issues and there's a democracy crisis because, in essence, those who are privileged are now dealing with issues that they haven't dealt with before in terms of Harvard and universities being targeted, and that hasn't happened before. But we're not necessarily dealing with the things that have been longstanding. And so, to give an example, I know one of the things that I read in the ABA statement was that they support the right of people to be able to plead their cause of action in court. And that was in response to Trump targeting judges and going after people who were filing lawsuits and things like that. But for the last few decades, the United States Supreme Court has been issuing decisions in terms of standing, absolute immunity, qualified immunity, municipal liability, race, discriminatory intent, a whole bunch of rules regarding civil procedure, all of which have served to close the courthouse doors to large swaths of the population. And yet the ABA has never issued a statement about any of those decisions or anything like that. And so I think what we need to be careful about with rule of law discourse is that we are not, in essence, reifying the same privilege that have always existed and thinking that the only time a crisis happens is when those who are in power are being bothered by it, or those who have been privileged are being bothered by it.
Jocelyn.
Yeah, I'm going to jump in and also, if it's okay, incorporate the question that we have in the Q&A.
That'd be fabulous.
Should I read it or just?
Sure.
I'll read parts of it. There's a question in the Q&A that I'll, go to the question part at the end. We're facing an autocratic state, so what actionable steps can be taken? The academic arguments are important, but cannot be the most important right now. What's being done right now to fight against autocratic state? And so I take that to be just a question about the relationship between action, the law, authoritarianism, and also just the ideas we're talking about. And I kind of want to defend the academic arguments as part of what can be done, as we absolutely use the laws that are available to push back against the autocratic state. And there are, yesterday there was a legal win in an AAUP lawsuit that, about rule of law ideas, right? You shouldn't be able to deport somebody because of speech that they made or political beliefs that they held. Yes, great, right? That's using laws and really sort of classic ideas of the rule of law to fight back against what's happening. But then there's also the question of how that case gets litigated and then how we talk about it, right? And the how we talk about it, I think, is equally important. We need them both. Because if we talk about it as, and the immigration system that we have was going great until we started trying to deport people for political speech, then we're missing out on so many connections that, that we could, list out the same histories if we're thinking about immigration, settler colonialism, and all kinds of histories in the US. And so to be able to say, that's a win. That's a win against authoritarianism. That's a win against fascism, but not because we should, the deportation is working great and as long as we don't target speech, right? That's, to be able to then make the turn and talk about our border policies, talk about how we could instead have a substantive vision for everyone who's here and helping people to thrive. And so it's about using both of them together. I think there is a lot of fighting happening. Some of it's using the law, using rule of law ideas, and some of it's not. Some of it's in defiance and resistance, and that can be equally powerful. So I guess another thing I would say in terms of thinking how we talk about action and how we act is that this is just not the time to say that we need to be doing everything, crossing our T's and dotting our I's and doing everything perfectly according to procedures and laws, because fascism has come for everybody. So I was sort of just like yes, action, yes, laws, but it's, we're not standing there with just this choice between Lincoln and slavery, right? We can articulate that other thing, and that's part of what intellectuals and academics can do.
Excellent. Samir.
You gotta unmute.
My fault. Yeah, to build off of that, the comment or the question made note of the civil rights movement being an example of the ability to make change. But the civil rights movement didn't just pop out of nowhere. It was a product of decades of organizing and decades of resistance and decades of struggle. The New Negro movement, for example, that was happening in the 1910s and the 1920s, was an artistic expression, it was a political movement, it was a cultural movement, it was an academic movement. And all of them were speaking to the issues that existed and were organizing and were writing and were publishing and things like that. And so I think in terms of what actionable steps can be taken, the same actionable steps that will be taken during the civil rights movement, the struggle doesn't stop just because the leadership habits have changed. And, during the 1880s, the 1890s, the 1900s, and the 1910s, it was the nadir of race relations. African Americans were being lynched 2 to 3 times per week, but that didn't stop the struggle. And so I don't think that we should be basing what we do entirely upon what kind of leadership we have, where when we have more rigid, harsh leadership, then we march in lockstep, I guess, better than we would during the civil rights movement, where we're supposed to be allowed to be bold. You have to be bold, just period.
I think just one thought just to follow on what Zamir and Jocelyn are talking about. So some folks in the chat also mentioned, like, we're lawyers, what's our role, right? And I think there's, that's a very good question. And one of the things that lawyers can do is, of course, they can bring lawsuits and they can be strategic and create space for some space for the kinds of better versions of the substantive justice or the rule of law that we're talking about. But I think that most of us who actually do engage with courts and our lawyers also really recognize the limits of that, right? And that, like, how far can you go with just litigation, right? And so it's important for us also to be thinking about the way lawyers can interact with movements. For example, lawyers played a lot of different roles in sort of the civil rights movement era, in the labor movement, and I think that it's not always litigation, right? It's not always in this sort of classic rule of law form, right? Where it's like, we're going to stand up there and, and make the argument that, the judge has to follow the law. Sometimes it's in, how do I help as a lawyer this movement build its power? Maybe it's getting somebody out of jail that day, or helping people do the kind of work that they need to do to have a demonstration, or maybe it's helping them incorporate in ways that are less vulnerable to the weaponization of 501c3 law right now, right? So there's a lot of things I think that lawyers actually can do that would articulate to the kind of organizing and civil rights politics that Zamir is talking about, that aren't often quite how we think about the role of lawyers, which is to say, some of what in the sort of law and political economy world and blog and things that, like, some of us are talking about, we're trying to do more to articulate that role for lawyers as kind of part of and able to play sometimes an important role in this kind of organizing, protest, civil rights style, so that we're not buttoned into something that's like, well, we're going to litigate, because that can be important, but it is often not going to be, I think we know it's not going to be sufficient.
So just to push that a little bit further, Jocelyn, you had said in your opening remarks that there are opportunities now, given where we are. And then you talked about sort of broadening the narrative and sort of to include other substantive values. Zamir, you talked about sort of movements and continuing those movements. And then Amy, you talked about lawyers as lawyers, and also broadening our conception of the lawyer's role to be able to participate with movements in different ways. So I'm curious what other opportunities you all see now to think about how we bring about a more equitable rule of law, or if we're going to talk about it more broadly or differently, what does a more equitable society look like? And what are the opportunities to get there?
It's actually funny. I have a student who is working on like lawyers' visions of the future as like a thesis project, and one of the things that she's increasingly finding is that oftentimes they don't have them. And I sort of feel like the moment that we just had kind of reflected that. As I feel like right now, sort of as lawyers. And sort of as lawyers sort of committed to equity, I know so many of us seem to feel a kind of profound despair. But I mean, maybe, so one of the things that I've been thinking about as sort of inauguration as a project is a kind of third reconstruction, if we count the civil rights movement as the second collective, where, scholars really start to think, after the Trump interregnum ends, assuming that the Trump interregnum ends, it's going to be incumbent upon us to do everything from get executive power under control, um, try to figure out what actually prevents the government from going crazy racist every time somebody gets mad, and implement that, to think about ideas like lustration, like how do we keep the people who are currently extracting money under the guise of things like Doge from having continued roles in government and continuing influence over government. And so maybe that's what we as scholars should be doing toward an equitable future, is trying to figure out what the institutional support of that future could be, assuming that one day the politics again turn toward it.
Yeah, Sloan. Thanks, Paul.
Yeah, thanks for that. I think our silence also reflected that you asked a lot of questions, like a lot of big, deep questions. The last one being, what should our substantive vision be? And one of the ones before that being, what should we be doing right now? And I feel pretty strongly that a double ALS panel of professors is not the group to articulate a substantive vision of where we should be, but is absolutely a place to brainstorm what we can be doing so as to support a broad movement-based, inclusive, democratic process of figuring out our substantive vision in a way that's emancipatory and moving away from our white supremacist and other inequitable origins. And so the ways to do that, I mean, Amy started to name some of them, thinking about how lawyers relate to movements, but it's also just like, as like people or professionals, or everyone to think about it, just wherever we are, trying to work past feeling frozen by being in community with other people. And then in those communities, we have these legal skills and privileges that we can use. I do think that for law professors, who are often inside of large universities, although I'm not, because I'm at a standalone law school, a lot of the fight has come to the university under Trump, right? And so people are, well, here at Brooklyn Law School, we founded an AUP chapter, but people are acting in solidarity with students who had encampments to protest what's happened, the genocide. There are people who are joining lawsuits like the AUP one that was decided this week, that are about students. There are different solidarities being forged, and sometimes it's using the law in litigation, but a lot of times it's not. A lot of times it's engaging in solidarity in other ways, but bringing in kind of, to the extent that legalism and being legalistic can be a strategy, it can be a very useful strategy right now, precisely because of the way that traditional ideas about law are being set aside by the Trump administration, opening up for us it's scary, but it also really does open up possibilities to try to think together with other people about the kind of world that we want to see. So I can stop there. I have more thoughts, but I want to hear what Samir is going to say.
So I was going to speak to something I think a little more basic in terms of what legal academics can do. I think the basic minimum that we can do is we can speak to these issues in our scholarship, and we can speak to them in our teaching. I taught criminal procedure over the summer. I've taught criminal procedure a few times now. And the way I teach criminal procedure, I do a racial justice history of criminal procedure. And I talk about how the Supreme Court, particularly over the past 5 years, has narrowed the rights of persons charged with crimes and has immunized the system and its players from liability through doctrines such as absolute immunity, qualified immunity, and all of that. And I speak to the injustice of a lot of the cases that we read in class. And I've lost count of how many times I've had students come to me and say that they appreciate that because a lot of professors don't do that. They talk about cases as if they're objective, as if the Supreme Court is being neutral and detached in terms of how they're deciding cases, and they're just not, and they've never been. And I think there is a strong appreciation that students have if that's spoken to more directly by the professors. If they give ear to the fact that, unfortunately, law is political and that the Supreme Court does have an agenda and a lot of the things that they do, and courts specifically have an agenda with a lot of the things that they do. So I think at a basic minimum, that's something we can do. Of course, organizing outside of legal academia, I think, is important too. But within legal academia, we can speak to these things and we can write to these things and not act as if the law is this objective, neutral, apolitical thing that it isn't and has never been.
Excellent. Amy or Paul, you want to have any more comments? We'll go back to Jocelyn, who said she had more to contribute there. Okay, I wanted to, I think we've addressed most of the questions that have come up, and I appreciate that. And a question we got earlier was, should we be concerned that as we articulate substantive values, different way of thinking about the rule of law that is more liberatory, realizing more of the aspirations than the reality of our history, are we anticipating that that will further attacks from the current administration? And how do you respond to that? Go ahead, Paul.
Yeah, so I've just kind of accept. I mean, so I guess there's different levels of attacks, right? So as individuals, I mean, I've just kind of accepted that right now we live in a bad faith. We live under a bad faith government that doesn't respect the First Amendment at all. Among all the other constitutional principles it doesn't expect. And so, I expected a minimum a tax audit sometime in the next few years. I mean, I carry a burner phone when I cross borders now. Like, that's just kind of where we are in this country. Like, Kash Patel is, and Pam Bondi and Stephen Miller weaponizing the government against people who disagree with them. There it is. I think, for our institutions, in a lot of ways, that's sort of easy to say as individuals, but I think one of the sort of things about the strategy that they're implementing is that there's a kind of divide and conquer strategy that we're seeing with academic institutions, where I mean, essentially with the attacks on research funding, sort of hard sciences are being played off against the humanities, and that kind of includes the law. And I think that many of us have seen that internally in the discussions with our universities. And so I think that to some extent we're going to require like much stronger work of institutional solidarities to support continuing efforts to actually, be on the side of progressive values and or the rule of law.
I'll add one thought in there too, Andrew, which is I think that one thing that is maybe useful to do now, so sort of building on what Paul is saying, sort of getting our heads around this new world that we're in, is to try to seek out kind of trainings, like things where people who are familiar with authoritarian like life explain how it works. Like, how does authoritarian power get exercised? Because even though we're talking about there's like a kind of a there's an authoritarian kernel to the state in general. We're experiencing something that is not that is different than, even if it's got elements that many people have experienced. Some of it might be about learning from those folks. So people like Jocelyn was talking about, like going back into our history and reading folks who have long dealt with and thought about power that is exercised in a kind of authoritarian and fascist way. There's also like new things available. I was actually just the other day looking at something called freedom trainers. They're groups that are training a lot of individuals actually to sort of understand authoritarianism and how it works. And it's interesting because it gives you perspective in a slightly different language to talk about sort of how important fear is, for example, to authoritarian rule, right? And then why something like Zamir's point about like talk about it in the classroom, actually talk about it. And in fact, it really is important in a different way. I think sometimes as you start to get your head around how power is being exercised right now, look at that decision yesterday that Jocelyn talked about. The judge deeply understood that there was never a plan to pick up every student. There was a plan to pick up some students and make everybody else terrified and shut up. And so like learning and tuning ourselves to how power is being exercised in this moment, I think is actually quite important to thinking about how to contest it strategically and in smart ways. And so that's like something I'm kind of trying to learn to do and can recommend, I think, as people are, because I think some of the tools we've been given, especially those of us who've been through law school, they do not equip us well for thinking about how to build particularly organized and more collective and more mass power in the present moment, given the circumstances that we're in.
Thank you. And thank you, Zamir, Paul, Jocelyn, Amy. I truly appreciate your thoughts, your comments, really thought-provoking. I hate to cut off this conversation, but I really appreciate it. And encourage everybody to attend the next webinar in this series, The Rule of Law, Lawyers and Indigenous Rights. That's Wednesday, October 22nd, 3 Eastern, 2 Central, 1 Mountain, 12 Pacific, and 9 in Hawaii. So thank you all very much. I really appreciate it.